Welcome everyone to another question and answer session live. My name is Samara Belitzky. I'm an employment lawyer at Samfiru Tumarkin, and I will be here once again for the next 30 minutes or so to answer all of your questions related to employment law, workplace issues, severance pay, terminations, layoffs, vaccination questions, mask mandate questions, rapid test questions, anything related to the workplace. Please ask your questions. I'm here to answer them. Like I said, for the next half an hour or so, I'll be here to answer all of your questions related to, like I said, employment law, anything COVID related or maybe not COVID related, severance pay, health and safety issues at work, harassment, whatever the case may be. Please send in your questions. I have a few things that I was planning on talking about today, because we're getting a lot of questions about the changes, at least in Ontario, that the provincial government has been making with respect to vaccination passports and soon to be removal of mask mandates. So with that comes a lot of people being asked to go back to the office. I will be talking about all of those things because those seem to be the burning questions. It's what everybody's been asking us about. So if you have questions of that nature, please, by all means, send them in. Happy to answer them. But I will be talking about that a little more generally while I wait for some questions to come in, since those are the real hot topics right now in employment law. So I have one question that just came in. So I'll get to that question right away, and then I'll get to talking about the topics. Like I said, the hot topics, if you will, in employment law of the last week or so, while I wait for the rest of your questions to come in. So I have a question here from Optimus Prime on YouTube, who says, I'm coming off of just over a year of LTD, so medical leave with long-term disability benefits, and I'm wondering if I am owed or entitled to the missed vacation time or pay. This is a very interesting question, and it's one that we get often enough. So while you're on medical leave, and it's important to know that when you are on medical leave, that's completely separate from whether you're receiving disability benefits. So oftentimes we hear about people on long-term disability, LTD, or short-term disability. Short-term is STD, that we often refer to it as. That is a separate claim that you would make to an insurance provider if you have a disability benefits policy, and then that provider may approve or deny your claim depending on the medical that you provide to support your claim, to support your request for disability benefits. But either way, whether you have a disability claim that's denied or approved, medical leave can still apply. So from an employer perspective, if you receive a note putting an employee on medical leave, you have to comply with that. The job has to be held for when the person returns. If you're an employee, the employer can certainly replace you while you're away, while you're on medical leave, but you do have your job that you have to go back to when you come back. So they can't completely replace you on a permanent basis. So having said that, when you're on medical leave, how it works with respect to vacation pay is that vacation pay is actually a percentage of the wages that you earn while you work. And so in order to be entitled to receive that, you actually have to have wages that you're earning from your employer that the vacation would be a percentage of. And so it's not that you would be owed the pay, but in terms of your time off, depending on the policy that your employer has in place with respect to vacation, if it's unpaid or paid, when you take the actual time off, you may still be entitled to time off depending on when you went off work and when you return. So if you have a specific question with respect to your vacation time off, feel free to email us. Feel free to email me specifically. You can always go to our website, employmentlawyer.ca. You can find my information there. Feel free to email me directly with, when you went off, when you were coming back, the exact dates, what your, employer's policy is, so we can really figure it out, because generally speaking, you're not owed the vacation pay because you're not actively working and earning wages, but there may be some situations where you would still be owed time off depending on the circumstances. And just for all of those who are watching, to clarify, because this is a very, very commonly asked question, when it comes to vacation, there isn't an entitlement to paid time off. There's an entitlement to time off. Some employers will provide a percentage of your pay, sometimes if it's 4%, if you have up to 5 years of service, that's the bare minimum. And after 5 years of service, the bare minimum would be 6%. And the time off is 2 weeks up to 5 years of service, and then it becomes 3 weeks moving forward. An employer can certainly provide more than that. They can provide more than the percentages or the amount of weeks I just mentioned, but those are the absolute bare minimums that must be provided. Now, the employer actually has the choice to provide paid time off or unpaid time off. And so if the vacation is going to be paid, then you don't receive a percentage on each paycheck, and you receive pay, your regular pay, like you would if you were working, while you're on vacation. If you get unpaid time off, that's fine. Then you would get the percentage, the 4% or the 6% or sometimes a higher amount on each paycheck. So it's one or the other that needs to be applied. So I just wanted to clarify that, because we often get questions about vacation pay, time off. Do I need to be paid for it? What's the percentage? So I wanted to just clarify that in case anybody watching had those questions. I'm getting a few more questions here that I will get to. I have a question from Julia on YouTube. I have a couple questions from Julia on YouTube. So the first question is, can my employer tell me I am not allowed to wear a mask in the workplace? And then I see there's a follow-up question here. If they fire me for wearing one, would that be wrongful dismissal or discrimination? All right, so a bunch of things to unpack here. So first of all, if you're wearing a mask in the workplace, assuming that that's for health and safety reasons, the employer really shouldn't have a problem with that unless it actually poses a health and safety risk at the workplace, which likely it wouldn't. So generally, it depends on the industry. But if you're not harming anybody, if you're not posing any sort of health and safety threat to anybody by wearing a mask, if there is no negative impact by you wearing the mask, there really shouldn't be an issue with it. They do have the ability to a point to tell you if you can, cover your face or not when it comes to, let's say customer service, customer facing jobs. That could be something that they would have an ability to do if, let's say, they have a written policy about it. Some employers have a policy where, for example, you can't have facial piercings, or you have to have your hair a certain way. Those types of policies can be reasonable and lawfully implemented in the workplace. So masking could potentially fall into some of those policies, depending on, again, your industry and the kind of job you have and the policies that your employer has. But in the vast, vast majority of cases, generally speaking, there would really be no reason for you not to be able to wear a mask. It wouldn't really pose an issue, a health and safety issue, any sort of issue for any of the workplaces I can think of, off the top of my head. So that sounds like a bit of an unreasonable stance if that's what your employer's doing. Now, to answer your second question, can they fire you for wearing one? So if you're wearing a mask for a medical reason, and what I mean by that is you may have an illness, or you may have some sort of medical condition or disability where your doctor has said that you need to wear a mask at work. If that's the case, then you need to provide a note or a letter from your doctor to your employer that says as much, that says for medical reasons, so-and-so needs to wear a mask, and it needs to provide the parameters for which you need to be wearing this mask. Then you would be triggering your employer's obligation to accommodate you, their duty to accommodate. So if that's the case, then they have to allow you to wear it. It's a legal obligation because it's for a medical reason. And if, let's say, they fired you because of that, then that would be discrimination, because they would be terminating your employment because of your medical condition, which requires you to wear a mask. If you don't have a medical condition, if you're just wearing a mask because you want to wear a mask, it's a just personal decision, and the employer does decide to terminate your employment, that would not be discrimination under the human rights legislation, under the Human Rights Code in Ontario. Okay. The employer is allowed to terminate your employment for reasons that are non-discriminatory. So oftentimes I get questions from people who are asking if they've been wrongfully dismissed because their employer let them go for a silly reason, for a ridiculous reason, or because they let them go but they were there longer than other employees, for example. So it's important to keep in mind that employment, unfortunately, is never guaranteed. So that means that an employer can terminate an employee, terminate their employment at almost any time for almost any reason. Now, there are exceptions to that, but generally speaking, they are allowed to do that as an employer, but they have to provide the appropriate amount of notice and or pay in lieu of notice or severance pay. Okay, so in the scenario we're talking about, if you're let go for wearing a mask, let's say, it sounds silly, but if, let's say, the employer decides to do that and there are no underlying human rights reasons for why you're wearing that mask, it's just a personal belief that's not covered by any of the grounds in the Human Rights Code, then that would be a regular termination without cause, and you would be owed your notice and or termination pay and severance pay. And if they don't provide that to you, or they don't, let's say, provide you with enough of those things, that's when it could be deemed a wrongful dismissal. So the term wrongful dismissal is not great. It's not a great name for it. What it really means, it doesn't mean that they were wrong to let you go. It doesn't mean they didn't have a good reason or any reason. What it really means is they let you go and they did not provide you with what they should have provided you with. That's what wrongful dismissal means. So in a case like the one you're describing, Julia, if that were to happen, if they were to let you go for wearing a mask where there's no human rights issue involved, then it would be a without cause termination and you'd be owed your severance, just like any other situation. Okay. Just looking through the rest of the questions that are coming in here. So I have a question from Free Domination on YouTube who says, I am on leave of absence without pay because I refuse to get vaccinated. Can I demand to just get fired to get my severance pay? We are unionized. So unfortunately, I cannot assist you because you're unionized. So if you're unionized, you have to go through your union. Only your union can assist you. You don't have the ability, because you're unionized, to hire a lawyer and take your employer to court. You'd have to file a grievance through your union, ideally. And the process that's available to you is the grievance process, which would lead to an arbitration hearing ultimately. So that's the process that needs to be followed if you're unionized. Non-unionized employees, certainly we can assist with these issues. But if you are unionized, unfortunately, there's very little we can do for you. We can give you advice, like I'm mentioning now. I can tell you, I can give you a legal opinion, but I can't actually represent you or act for you with respect to this situation. What I can say, just to provide you with some, very general advice, is if you've been put on an unpaid leave, likely there is something in your collective agreement that may address the situation. So you should look at that and see if there may be something there that can provide assistance. Talk to your union rep, see what they're doing for folks like yourself who've been put on unpaid leave. They may not be doing anything. They may decide they're not going to be helping you, which unfortunately they can do. But it's definitely worth having a conversation and seeing, especially as things start to change and, vaccination passports are being removed, mandates are being removed, things are, knock on wood, starting to get back to normal. There may be a change at the workplace where you get returned back to work. But from a legal perspective, there likely isn't anything in the collective agreement that allows you to simply ask for your severance because you've been put on an end. That's a question for your union, and it would be governed by your collective agreement. So I have a question from Keith Smith on YouTube that says, I'm going to arbitration for an unemployment claim. Can I still settle my claim in arbitration, please? I'm not sure what you're referring to in your question, Keith. So if you want to just send in a follow-up question, I'll be happy to answer it. If you are unionized, if you're going to arbitration, it's possible that you're unionized, in which case it may be difficult for us to provide assistance. But generally speaking, even in a unionized setting, if you have a grievance and you're going to arbitration, there's always an ability to settle. Usually at the beginning of arbitration hearings, there will be an effort made by the arbitrator to see if there's a way to settle the case before moving forward with the actual hearing. And so that's something to keep in mind moving forward. If that doesn't address your question, Keith, just send a follow-up question with more detail. I have another question here from the Dreamer from YouTube, who asks, is an employment contract enforceable if certain sections of the contract were signed after employment began and can prove it? So in terms of employment contracts and enforceability, there are several different scenarios that could arise. But if, let's say, you sign a contract before you start your work, and then years down the line, they want you to sign a new contract, they have to provide you with consideration. And the same thing would apply even if you didn't sign a contract at the beginning, and then even if it's a few days into your employment, but anytime after you start and they want you to then sign a contract, that's a change to the terms and conditions of your employment. So whether it's going from no contract to a contract, or one contract with going to a different contract, those are changes to the terms and conditions of your employment. Even if sometimes it doesn't look like there are changes, they are changes. And because of that, an employer who wants an employee to sign that contract needs to provide what's called consideration. And what that means is that an employer needs to give the employee something in exchange for agreeing to these new terms and conditions of employment. And it doesn't have to be, a significant amount of money, depending on what they're asking for you to sign, depending on the changes to your employment, that could dictate how much money would be considered adequate consideration for you as an employee. But that has to be provided. There has to be something being provided in exchange for your agreement, for you signing the new contract. It can be a signing bonus, as I mentioned. It can be a wage increase. They can increase your hourly wage. They can increase your salary. Basically anything that's extra, anything that you will now be receiving that you didn't have before, that would be consideration. And without consideration, the contract is not enforceable. So if a contract is signed in the scenarios that we just discussed, and there is no consideration provided, then the contract cannot be enforceable. And it's really important to note that continuation of employment is not adequate consideration. Meaning, if the employer says to you, sign this or I'm going to fire you, but if you sign it, I'll keep you employed, I'll continue employing you, that's not consideration, because your employment was going to continue anyway. It has to be something more than that. It has to be something extra, not just continued employment. So to get back to your question, it's going to be tough, because if some sections were signed before you started and others were signed after, then you probably have a situation where part of the contract may be enforceable and others may not. It depends on how the contract was drafted. It depends on, what the sections were at which time. So it's a very it's a very interesting situation. But I can tell you, if you didn't receive consideration for the sections that you agreed to or signed after you started employment, then those sections will not be enforceable. And if you do want to have that reviewed I do suggest that you get in touch with us. You can schedule a consultation. We can review the contract. We can discuss the situation with you and let you know where you stand in terms of the enforceability of your contract, which parts might be enforceable, unenforceable, whatever it may be. You can go to employmentlawyer.ca. You can contact us that way. My contact information is there. Feel free to contact me directly, or you can contact the firm generally, and they'll be able to connect you with another lawyer, whatever your preference may be. But certainly that's a situation worth looking a little further at. I have a question from Megan on YouTube who says, I was laid off due to my choice not to become vaccinated. I was employed for 2 years. Would I be entitled to severance? So as long as you did not work in an industry that was mandated by the government to be vaccinated, yes, you would be entitled to severance. So if the only real mandates that existed and continue to exist were in the long-term care field. So if you worked at a long-term care home, that's where it was mandated. In the healthcare sector, it was mandated to either be vaccinated or participate in rapid testing. And at the federal level, we know there were federal government mandates. Anybody working for the core public administration for the federal government, there was that mandate as well, which would mostly affect a lot of people working in Ottawa where I practice. So if you don't fall into any of those categories and there was no mandate, then yes, you would be owed severance for your termination, and you should certainly get in touch with us so that we can go over that with you, Megan. You can use our severance calculator online if you want to get an idea of what you could be entitled to receive, or our pocket employment lawyer. It's pocketemploymentlawyer.ca. You can visit that website and get an idea of how much severance you could be owed. I have a question here from Randolph on YouTube who says, I have changed positions a few times with my current employer and have never signed a new employment contract. Is my original employment contract what would dictate my severance? So if you have a contract that you signed at the beginning that does address termination entitlements, it may impact your severance at this time. It depends on a few things. So the first thing to keep in mind is if you signed a contract many years ago, even if it does address your termination entitlements, it likely isn't enforceable in limiting you today. And that's because the law has changed quite a bit since then. The law changes, every so often. And so when it comes to termination clauses, unless it's a very recent one drafted by an expert employment lawyer, the odds are it's not enforceable anyway. So that's the first thing to keep in mind. The second thing to keep in mind is depending on how the contract was drafted, it may no longer apply to you depending on the position changes that you've had. So there is a legal principle, a legal argument called substratum, which means that if you were in, let's say, an entry-level position when you started your employment, and now you've been promoted over the years, you've never signed a new contract, and you're in a director position or an upper management position, then the nature of your new or your most recent position is so substantially and significantly different than the one for which you signed that contract that contract no longer applies to you. So you may in fact have that argument, Randolph, depending on where you started and what position you're in at the time of a potential termination. So if that does happen, if you end up in a situation where your employment has been terminated, definitely get in touch with us. We can review the situation with you. We can review the contract and let you know if in fact the contract even limits you to begin with. And if it does, we may be able to look at other arguments to assist you depending on the situation. So definitely if you're let go, do not sign anything, get in touch with us right away, and we can assist you with your severance. I have a question from Dan Johnston, which is one that we have been getting a lot. So Dan from YouTube says, the government said that federally regulated businesses would have vaccine mandates, but I don't think they ever passed that into law. I was let go anyway. What if they don't pass that law? So you're right, it hasn't been passed into law. We actually haven't heard anything further about this in quite some time. I don't want to say that maybe they've decided not to do that, but it is certainly what it's looking like, but we have to see. As of today, they haven't put that into place. So there are certain federally regulated businesses that were mandated in the transport industry. That did happen in 2021 last year. But when it comes to all federally regulated business, which is what the federal government said they were going to do, they haven't done it yet. So if you are working for a federally regulated employer, there is no mandate, and the same legal analysis would apply as any other employer. If there is no legal mandate and you are put on an unpaid leave or you are terminated, you're owed severance pay. So if you're in that situation, Dan, get in touch with us right away. You can go to our website, employmentlawyer.ca. Feel free to contact me directly. All my contact information is on our website. And we can discuss your situation, and certainly I can help you in pursuing severance because certainly that mandate did not come into place. And even if it does in the future, if your employer jumped the gun by letting you go before the mandate came into place, you're still owed severance. It's just a question of how much. All right. I have a lot of questions here. I'm not going to be able to get to all of them, unfortunately. So I'll see if I can get to one more shorter one. And then if we didn't answer your question today, there is another session on Monday with my colleague, and you can certainly ask your question at that time. Or again, you can contact us by phone, by email, help@employmentlawyer.ca. You can contact any of our lawyers directly to address your question. So I'm just looking for a question that I'll be able to answer in a relatively short time. So I have a question here from Judy on Facebook who says, I've been a contractor for the same company for 12 and a half years. I heard Leah is a lawyer in our Vancouver office, once say on your radio show that companies should renew contracts occasionally, but that has never occurred here. I've also asked but never received a raise, and they have a year and a half ago done a few changes, such as removing the contractors from their email system and made us get our own emails, but still use their signature logo. Is that a potential sign they're worried they've crossed any lines between me being a contractor versus an employee? I'm sure, Judy, there is a lot more to it. There always is, especially dealing with these contractor worker status cases, which we see, quite frequently. Maybe they're wise to the fact that, looks like maybe on paper, or they call the employees contractors, but in fact they're employees. I will say this, in terms of whether somebody is an employee or a dependent contractor or an independent contractor, because there are those three categories, at least in Ontario, there is a global analysis to be done. So there are several different factors that the courts look at. They don't look at just one thing. They look at many different things and they weigh them all together. So the fact that they changed your email, that now militates in favor of maybe a contractor argument because, you're not using their email, you're using your own. But that's just one small factor in many different factors. The equipment and who supplies the equipment is one factor, who sets the schedule, the way in which you do your work. There are so many different factors that go into the analysis. But the main thing that all of these factors come back to is the degree of control. And if it's clear that the company is really controlling the manner in which you're doing your job, how, when, where, all of these things, then that does militate in favor of a finding that you're an employee rather than a contractor. So Judy, if you are interested in kind of discussing it, I know you said there's a lot more to it. I'm sure there is. If you are interested in discussing it further and getting a more comprehensive legal opinion on what you might be, definitely get in touch with us, and we can review the situation with you in detail and discuss that with you. So that brings us to the end of our session today. Unfortunately, I didn't get to talking about the new removal of the vaccine passports and the mandates, but that's okay. I'd much rather answer all of your questions. However, if you do have questions of that nature about going back to work now that things are changing, mandates are being removed, returning to the office after working remotely, mask mandates being removed, and health and safety at work, any of those things, please do get in touch with us, and we can assist you with whatever the issue might be. So thank you very much, everybody, for joining us today. Thank you for your questions, and I hope that everybody has a wonderful weekend.